Thank you for that. Concise, short, to the point, interesting. Thanks for that. Please feel free to take a seat. You will be joined on the panel, first of all, by our moderator, Tom Penn of the Tokenizer. He's coming there. Ronald Frankl, Managing Partner, LGP, attorneys at law. LGP together with UFin Law on our list of sponsors as well. So thanks for facilitating this panel. Dimitrios Psarrakis, Head of EU and Financial Strategy at XReg Consulting, and Matic Nedog, Head of Legal at Cryptix and Equito, another of our sponsors, is coming there. Tom, I'm handing over to you. Thank you so much for joining our panel. Last one is coming there. Fantastic. And we're looking forward to a hopefully heated discussion on regulation. Thank you so much.
Cool. Can everyone hear me? First things first. Thumbs up. Many thumbs up. Excellent. Fantastic. Yeah, you say I'm Tom Penn from the Tokenizer. Here to talk about the juicy, sexiest thing in the world, regulation, in this wonderful sector that we're in. I know everyone else has said it already, but I think I should say a big thanks to the organisers and the sponsors again. When we launched the Tokenizer 4 years ago, I remember explicitly saying to our team, when's there going to be a conference just about security tokens? And it's brilliant, 4 years down the line, here we are. I'm particularly interested in this discussion because we recently launched, I'd say the last few months, something called the Token Reg Radar, which is a software as a service platform designed to provide global regulatory clarity for the sector. And I'll be around to talk to anyone, everyone, later on in the day as well. But yeah, I'm from the Tokenizer. We're the news platform for the tokenization sector. And if you or any of your colleagues don't go on our website every day, then I don't know what you're doing, frankly. Please start doing so and reading about all the news happening in this great industry. Let's introduce everyone. I'll leave Lutz to go last. No offense, but I think people know you already. But we'll start over at the far right. Just a brief introduction about yourself and why you're here.
Yeah, thank you. Yeah, I'm Matic Nedog. I come from Cryptix. I'm responsible for legal matters there, head of legal. So Cryptix is basically, let's say, a venture building platform providing or facilitating different businesses and projects with the use of innovative technology, mainly focused on fintech industry. One of its prominent projects is Equito, the investment firm licensed under MiFID to perform various investment services, including placement services, transmission of orders, execution of orders, and also custody services. Yeah, that's about it in short.
Can you hear me? Good. My name is Dimitrios Psarrakis. I'm heading the European Union office of XReg Consulting, which is a boutique consulting helping some of the major players, token issuers, and crypto exchanges to navigate the regulatory strategy in the European Union. Before that, for 7 years, I was in Economic and Monetary Policy Committee of the European Parliament, specialist on digital finance. I worked with Vice President of the European Parliament, Eva Kaili. I was a draftsperson of the blockchain resolution of the European Parliament, and I was in the MiCA world and DLT world from their inception. My last regulation was the DLT pilot regime before leaving the office.
My name is Ronald Frankl. I'm an attorney at law in Vienna, and I'm a managing partner at LANSKY, GANZGER, GOETH, Frankl & Partners, which is one of the larger law firms in Vienna. I'm heading there the corporate M&A and capital markets department, and I would say capital markets, this topic was some kind of my entrance door also to the topic of blockchain. Actually, first it started, let's say, the beginning of 2017. It was more like a hobby when I was dealing with the first requests in this practice area. In the end of 2017, then I was engaged by, I would say, around 100 investors who incurred damages by investing in an abusive investment scheme based on Bitcoins. There was also a lot of media coverage, which motivated me to go more and more into these topics. And in 2019, I more and more started to also, let's say, develop the legal advice as regards to support companies, entrepreneurs, to exploit the potential of the blockchain, in particular, if it comes to raising capital. And I think the most common topic in this context is tokenization. And this is actually why I ended up here.
Lutz, let's hear you again.
Yeah, okay, you already, no, actually David already introduced me, so maybe some words about FinLaw as a law firm. We are Frankfurt based, we are kind of a boutique law firm, I would say, and really focusing on everything that has to do with blockchain regulation. I was working in the field since 2012 already. Back in the day, as I told you, it was all about Bitcoin. Today is a bit different. And so we mainly have two fields of practice, which is, first of all, everything that has to do with financial services regulation when it comes to crypto assets, like licensing, registration, applying, anti-money laundering, prevention, and so on. And on the other hand, tokenization of assets and security token offerings, drafting up the prospectuses, get the approvals from BaFin or other regulators in Europe as well. So yeah, do that together with my partner Konrad, who sits over there. Say hi, Konrad. Yeah, and that's the next FinLaw partner who's here. Yeah, so that's me.
Great, okay, fantastic. And as with the first panel, any questions, please do jump in at any point and put your hand up, and we'll come to you straight away. I'm going to start again with Lutz. You've just given us a brilliant overview of the European landscape, I guess, where we've come from, where we've got to, and where we might be going next. And we're going to talk about the DLT pilot regime further on, no doubt. But going along the line, really interested to know what the regulatory landscape is in your particular home country or the area that you do your most work in. We're in Germany. Let's start with you, Lutz.
Okay, yeah, thank you. So I think Christian already in his keynote told us that Germany is actually a hotspot for blockchain regulation and an innovative place. And that is actually from the regulatory part true, because we have in place already some special regulation when it comes to security tokens. In the first place, actually, back in February 2019, we had in Germany the first actual security token offering. And BaFin was quite open-minded in that regard. So they said, we don't have a problem with that. Usually from a private law perspective in Germany, it is still necessary, well, not today, I'll come to that later, but it would be possible, it would be necessary to have a paper-based security, which is actually held by a central securities depository. And, but BaFin said, okay, since we are dealing here with European regulations and the private law of Germany is not applicable in this regard, it is also possible to put everything or all the rights that are associated with a security, to put that all in a token. And we accept that you do so. And if you draw up a prospectus which complies with all the rules, we will approve that and you can offer that publicly. Yeah, so it was already possible since 2019. That was actually not the first country. I think Austria was even earlier, as far as I know. But still, that it's possible was really a big step. Yeah, it was really good. And then the legislator actually on the national level saw quite early that it would be necessary to find also some answers to the private law problems. Yeah, because the securities trading market is really paper-based, and the reason for that is that in private law, in German private law, we have the possibility to acquire a tangible asset, which is a paper, yeah, a tangible asset in good faith. So it doesn't matter if the one who sells the paper to you is really does really own it. Yeah? So even if he doesn't own it, but you don't know about that, it's possible to get it. Yeah? So that is really important for trading securities. So what we did before was always to construct something in a closed system. Yeah, so one platform and to draft up terms and conditions everyone who invests in that specific token would have to consent to. Yeah, so that everyone deals with the same rules and knows, okay, once I own the token, I also own the rights associated with that token. And now we have the possibility to really issue crypto securities. Yeah, that's a private law figure now, what we have since last summer, 2021 in Germany. What is necessary is actually to have a central crypto securities registrar who puts all the information related to the issuance of that token into a specific register, and then it's possible actually to also to transfer the token and acquire the token in good faith from the private law perspective. So that is really something on the national level which was maybe driven by the possibilities that came up with security tokens in the first form. And now we have that. So you can see that Germany and the legislator in Germany is actually really making some efforts to contribute to that market.
You seem quite pleased with them.
Yeah.
Excellent. Ronald.
The current situation, and as we have it today in Austria, is as a legal advisor mainly characterized by applying the traditional capital markets regime as it applies all over the European Union to all these, let's say, token schemes. So if you, for example, are going to make a security token offering, of course, then you have all the disclosure regulations laid down in all the directives and regulations apply. But on the other hand, I would say the Austrian regulator is quite open to all, let's say, these kind of transactions. And you have a very good discussion basis with them to specifically apply those, let's say, concepts which were conceived for more traditional concepts to, let's say, a token offering. And this also applies to, let's say, any kind of companies who deal with token concepts like investment firms. Also in this concept, of course, you have the possibility to first go to the regulator and check up, let's say you come up with your own legal view, and you can have this confirmed with a statement of the regulator. You can also get the input and feedback of the regulator to all these concept ideas, and based, let's say, on your own ideas, in combination with the feedback of the regulator, you can go then and implement this concept. This goes so far that that people, firms establishing some kind of a trade in security tokens as an investment firm. Of course, this does not involve a trade as we know it in an order matching system. Yeah, it's more like bringing together people in a discretionary way. Of course, I would say one specific thing which we have in Austria is that we have this, let's say, this concept of virtual asset service provider. This is a result of the 5th anti-money laundering directive. And this was the way how Austria implemented it at the end of the day. If someone who is considered such virtual asset service provider, like someone running an exchange platform or operating issues, or also the depository services, wallets, they of course have to fulfill anti-money laundering obligations. They have to do an onboarding, but also not to mistake this. This is not, let's say, a licensing, yeah, in this way. It's more a registration. It's a registration with the FMA, with the Austrian regulator, which then obliges you to, let's say, undergo all these onboarding procedures with any investors, of course, accessing the platform. And this is, and only those, let's say, procedures are also subject to the supervision. It's not the activity itself. this is something which might come. And of course, we are now, let's say, in the situation, MiCAR is to come, and also the DLT pilot regime, and this will, of course, change a lot in this respect.
Yeah, cool. We'll certainly come on to that.
Yeah.
Not too distant future. So quite another friendly landscape, we'd say, in Austria.
It is. I would say it is. Sometimes it's a challenge because you have to really deal with all these traditional legal concepts and to let's say apply them on very new and progressive concepts. But it's feasible still, and I have made the experience so far with the regulator that that the contact persons there are open to discussion. So there is enough flexibility also on the part of the regulator to make these concepts work at the end of the day.
Great. Going down the line further.
Well, as long as I consider my jurisdiction the entire European Union, can we go to the colleague here and then conclude this round?
Yes, no problem.
Okay, yeah. So from my side, it's hard for me to speak for one specific jurisdiction since we are involved in several of them. So yeah, I would agree with the notion that, let's say, BaFin is somehow trendsetter in the European region, you know. But yeah, I found it interesting, this legal concept of what colleague Lutz mentioned. But what does this actually mean is that you have a paper share, which is technically a bearer share, you know. So you don't really have a register, and the problem for the issuers, if they issue bearer shares, they are automatically high risk under the AML KYC legislation. So we somehow need to find some solution that they are still registered in some form of register. Of course, this can be also blockchain, you know, but currently there is no real consent or, let's say, motivation for central securities depositories, which would be, in my opinion, the right entities to introduce this technology. Yeah.
So, well, we are in an environment that we have, at least in the European Union, some jurisdictions with already a prudential regime in place, some jurisdictions, the most of them with just an anti-money laundering regime in place, and European Union stepped in, providing MiCA, which is going to be the uniform application of the prudential side for crypto asset service providers and issuers of tokens that are predominantly stable coins. But I want to go a little bit back in 2017, when we had the early hype of Bitcoin. Back then, the very idea of regulating blockchain crypto assets was equivalent to hubris, because back then, at least in the corridors of the European Parliament, Bitcoin was just something that scammers have created to get the money of innocent people, or to do money laundering and perform illegal activities. In 2017, do you remember who was the Minister of Finance of Greece in 2017? Well, it was Yannis Varoufakis. Are you familiar with his name? Well, in his broad affair with Mario Draghi back then, he said, if the European Central Bank does not want to provide us with the liquidity we want, then we will transfer all the bank accounts of Greece into Bitcoin. And all the payments of the state of Greece is going to be performed with IOUs. So back then, working with Eva Kaili in the European Parliament, we wanted to explore more what this Bitcoin is. So we drafted a question to Mario Draghi. Mario Draghi usually responds in 2 lines, but in this case, he replied in 2 pages, saying that Bitcoin, crypto assets, is something that will never be part of the European payment system. We should not speak about it as money, and this is where the story ends, this in 2 pages. So if the bankers don't like it, most probably it's a good thing. We asked for the European Parliament to give us the mandate to draft a blockchain resolution. And why I'm mentioning this blockchain resolution? Because in this, we spoke about tokenization of securities. the possibility to scale up funding for innovative startups that are now marginalized by the current venture capital and private equity market in Europe, about democratizing access to finance and helping the people have an alternative, especially when they are unbankable, when the 18% of the European citizens are unbankable. So when people ask me 5 years later if I'm happy with the European approach to regulating crypto assets, I reply I'm 65.9% happy. First of all, because I don't want to give the impression that I'm 70% happy. And I will give you exactly now what's the problem with the approach we have in the European Union. The blockchain resolution asked for a tokens regulation that regulates everything, which is in tokenized form. Unfortunately, the regulators are lazy. And in the case of the European Union, the French regulators and the German regulators are very lazy too. So instead of trying to create a brand new box and facilitate the existence of this brand new instrument, they took the old boxes and they tried to push hard there all the new forms of tokens. So they took the securities regulation, MiFID, and they said, we will push everything there if the token looks like a security. If it's a payment instrument, we will push everything there as if the old box applies to the new ones. And for the new things, we will create MiCA. The only aspect that escaped this mentality, in my view, is not MiCA, is the DLT pilot regime, but it's the next round we are going to discuss.
Absolutely. Quite a few nodding heads there, people agreeing with what was being said. So if we go on to the DLT pilot regime, beautifully brought in there, on time, we've got 35 minutes to discuss it, but let's not spend all 35 minutes on it. But Lutz, you gave a brilliant overview and of all the different regulations. I think you were able to dedicate 10 seconds and one sentence to DLT pilot regime 10 minutes ago. Could you, for the benefit of everyone, give a bit more of an overview, and then we'll talk about it in more detail?
Yeah, in my view, actually, the problem is that we still have some lack in the infrastructure for security tokens on that market. So it is really not possible currently to trade security tokens on regulated markets as would be possible with stock shares or even bonds or traditional financial instruments. Yeah, so that is actually the problem. Why is that problematic? Because as the current situation is, securities have to be booked into a register with a CSD. Yeah, so and the CSD, if they don't do it, it's not possible to list security tokens on regulated exchanges. And actually, they are still, well, from the German point of view, actually, they are still used to the paper-based system, and they simply do not have the approach or the techniques to provide everything that is necessary for security tokens, yeah, to list them on regulated exchanges. And there, the DLT regime will come in and make it possible that for smaller issuances, yeah, not for everything, but for smaller issuances, it will be possible that the investment firms, for example, simply do the job of the CSD on their own, or they will make it possible that a CSD is not necessary for such projects. Yeah, so, or that the market operators already operating regulated exchanges do not have to comply with the requirement of the CSD necessity. So this is kind of a sandbox, I would say, because we really try it out with smaller issuances and see what happens. Yeah? Does it work? Is it possible to do so? And yeah, where will bring us this new regime?
Okay, and go on to Ronald. Do you with the regime, the pilot regime, do you think this is a sign of Europe really saying we want to lead in this sector? Do you think it's something to be really positive about?
I think it's very encouraging, because I think it's the most progressive step Europe has taken on a legislative basis so far in this entire area, because I totally agree with what you said, yeah, because now and this is also what I said, we always try to apply traditional regimes, yeah, which are conceived for something else, always to these very new concepts, yeah. But now this is the very first time where you let's say respond, yeah, to the possibilities of the blockchain technology. Because why? I mean, I would say the two most important new developments of the pilot regime is on the one hand that market participants, yeah, will have direct access to any kind of exchange platform, because in the traditional world I need financial intermediaries for that. I cannot access directly. This is something which is of course perfect, and it also fits to this entire concept of blockchain, because so this enables investors also by using an app on the iPhone or on any kind of cell, yeah, to make trades. This is one, and the other is the CSD topic. And now it's possible that the investment firm operating the platform can at the same time also do all the settlement, all the custody services, everything. And this combination is, in my view, revolutionary, because this was the main obstacle so far. And when I was invited, now I would say in recent years, I have to say, to events, and I was requested to tell and to speak about advantages of tokenization, in particular in the real estate industry. I was explaining a lot, and many times I was facing the question from the audience, okay, if this is also good, why don't we read every day in the newspapers about one transaction after the other? And I mean, it was a vital question, yeah, because, and my first question was because we have a lack of liquidity. Actually, there was no secondary market for those security tokens, and I'm convinced, maybe I'm also a little bit biased, I have to admit, but I'm convinced that entering into force of this DLT pilot regime will become a game changer in this respect. I mean, it's not, we don't have to make now wrong conclusions. Of course, the general legal regime stays the same, but just opening the opportunity to get exempted, yeah, from these hard requirements, I think this opens up a big opportunity, and I think we will say that I'm convinced that this will also stimulate a lot of entrepreneurs and companies to make issues, because I have had conversation with a lot of, let's say, entrepreneurs who are highly interested in this entire concept of security token offerings, in particular in real estate developers, but who told me very frankly, we are not doing this until there is some kind of secondary market, because this is what we want to achieve. We see the fantasy and all the opportunity, and we are in the real estate business, and real estate is a very illiquid asset, and the upside here is creating liquidity for an illiquid asset. And this becomes possible now.
Great, yeah, and I think we'll come and talk a bit more about some specific sectors, looking at security tokens a little bit later as well. Any other further thoughts on the DLT pilot regime from any on the panel?
I would have to agree. So this DLT pilot regime is nothing short of revolutionary. For example, speaking from first-hand experience, so unfortunately, we were somehow ahead of time during, let's say, 2018, where we actually tried to overcome this intermediation requirement, meaning that in order for a retail customer to access a trading venue, like MTF would need to have some intermediary in between, like broker, like for example. So technically, there is no legal restriction explicitly written anywhere in MiFID that single investment firm cannot operate at the same time standard brokerage services and at the same time multilateral trading facility. However, we got very strong feedback from the regulators saying, look, you're somehow right, but you need to build their exact words were, you need to build a Chinese wall in between those two services, you know. But this was essentially would mean that you need to duplicate all of the services, all of the personnel, all of the systems, which would technically bring you to the end result of having equal costs like having two investment firms, you know. So from that perspective, where DLT pilot regime is actually providing sufficient legal grounds for investment firms to apply for certain exemptions, therefore, actually to simplify certain procedures which are in place in the trading functions and also in the post-trading function, which is also very important because currently we have like settlements, we have central counterparties, we have central securities, depositories, which are somehow, in some cases, different entities. And in order for someone to convince, let's say you're an issuer and you want to achieve that some security token is being able to be registered on, let's say, existing central securities deposit, you would also convince other actors to play this game, you know. So yeah.
Look at this from. You can look at this from the entirety of the value chain in financial services. You have listing, trading, settlement, clearing, and settlement all the way. If you go to the United States and you tell them, I'm going to shut down the clearing houses, they will hang you, and they will burn you alive. The moment I was allocated to work on this file, the very first morning, the day after, I received a call from the Euro clearing houses. They wanted to speak to me. Of course, I took the call. And the lady who was running it told me, do you know that the clearing houses are like taxation? They are matter of national pride. We have 28 clearing houses in the European Union. Every country has one, except for France that has two. The reason why we don't use technology in order to do this stuff, it's not because we lack technology, the lady told me. It's because we want to ensure market integrity. This is the reason why we need all these functions to take place in different silos. Why do you believe that blockchain can improve the value chain? I asked her because if designed properly, blockchain is a proof machine and you can do everything in one transaction. Yes, but no, it's not how things work. We need to ensure market integrity. Well, I'm not familiar of any other occasion that European Union drafted a regulation for a sandwich. I'm very happy that they did it. Obviously, they see all the market needs you describe over here. And I don't know if you had the opportunity to review the ESMA's report that was published 3 or 4 days ago about the DLT pilot regime. They had a consultation. They asked people like you, what's your feeling? Does it improve something? Well, the consultation was very straightforward. They said, improves. First of all, when we are talking about blockchain, we are talking about two things: transaction costs and verification costs. Does this idea improve stuff? The people who work in this field said, we have better market integrity, we have better access to information, more transparency, we have better understanding of how the asset changes hands. Of course, does not solve fundamental economic problems that all blockchains face. When we have a problem of matching a transaction between two different assets, we still have this problem in the DLT pilot regime environment because this is a crypto assets market problem. This cannot be solved. We have technical challenges over there as well, interoperability problems. Private blockchains permissionless blockchains. The regulation, in its wisdom, allows you to play with both. But if you play a lot with permission blockchains, you compromise the idea of transparency. You lose sight of what's going on. And on the regulatory level, obviously, different jurisdictions have completely different approaches of how they are going to implement this regime. Some jurisdictions don't want to talk about it. Some others want to talk about it, but they don't want to do anything about it. And some will start exploring this. I'm very confident that the people from Germany and Austria are blessed to have regulatory authorities that will push forward, but colleagues from other places are not going to be so blessed. So DigiFISMA and the European supervisory authorities need still to push forward towards this direction.
Glowing words for Germany and Austria, and able to name names of the ones which you're not quite so positive about?
Greece.
There we go.
Well, actually, this is something that Germany is immunized. We have BaFin here. You have both supervising of banks and financial markets in one place. You have other jurisdictions like France that they have double regulation, but they work very well. But the 90% of the case of the European Union, they don't even speak to each other. And when you want to develop a sandbox, and you have, for example, the crowdfunding platforms regulation that preceded MiCA, and you have lending, and you have equities, and you need to have one sandbox, and the banking supervisor does not coordinate with the financial market supervisor, it's a very big problem, very big hurdle. Well, I said many good things about Germany. There was another bad thing I want to mention. Also, Germany needs to improve its regulatory frameworks. I mean, when I was working on the crowdfunding platforms regulation, which has touch points with what we are talking here, the German colleagues came to me and they said, no lending, no lending. Why no lending? Because in Weimar Republic, because we had this regulation that prevents somebody to lend if they are not a banking institution and lending institution. Come on, it was in Weimar Republic. Things like that don't change very fast. And things like that generate mentalities.
Cool, and we'll probably take some questions on the DLT pilot regime, I think, very shortly. Before we do that, though, and more general questions as well, we talked about America being hung, drawn, and quartered quite graphically there. In terms of other countries outside of Europe, and I appreciate you guys generally work in your own jurisdictions, are there any particular countries that you think have got a brilliant regulatory landscape, or are ones which are really worth keeping an eye on or worth flagging up? Start with you, Lutz.
I don't know, probably, well, again, taking a look at Germany, from the very beginning, actually, already back in 2013, BaFin stated that they have the administrative practice to qualify Bitcoin and any comparable clone as financial instruments, and that meant that we already had a full regulation as financial service provider once you have a business model relating to crypto assets in any way. Yeah, so we already had very strict regulation at that time, and if you take into consideration that at that time, actually, the players in that market were not that professional as today. It was impossible, actually, to do business in Germany relating to crypto assets or security tokens or whatever. It was not possible. So what did the people do? Everyone went to Austria or to the Netherlands or to Czech Republic, for example. That happened quite a lot of times because those jurisdictions did not have any regulation in place so far, and they didn't qualify crypto assets as financial instruments. Yeah, so they were free to do their business, see if it works, and then maybe come back later to Germany. And you always have to take a look at the time you're living in currently. Yeah, so you can now say, okay, Germany was quick. Germany had a good idea of the approach they want to take. But back in those days, it served the purpose just to prevent that people do business with Bitcoins. Yeah? That was the reason.
Yeah.
Yeah, so all the banks I talked to back in 2013 were really reluctant and said, okay, of course we have the licenses, we could do it, but we don't want to. This is criminal things. We don't want to have anything to do with that. And so did the legislator as well, and the regulator as well. Yeah, so now maybe it looks like Germany was really quick and open-minded to put in place some regulation for that, but back in the days, that's actually my personal opinion. Yeah, but still, I would say, okay, they simply wanted to avoid that people do business with that in Germany.
Yeah, Ronald.
I think that this is also an example. I mean, you could see this from two ends, because on the one hand, I also experienced that many people came to Austria because it was more free, of course, but on the other hand, specifically that currencies, but also NFTs were considered financial instruments. It also served the purpose of legal certainty, because you know that was a regime and which rules applied. I mean, on the other hand, we really, when we had the first times we had to advise on NFTs, we really had to check in what applies and how to cope with, how to deal with this in a legal way, and what do we need. And I think maybe it's a little bit harsh to put everything into one box and say it's all a financial instrument, but on the other hand, you create some legal certainty. But also, I think if you because you asked what is better in some other countries, I think in Austria, I think what also needs to change is the general attitude towards this entire topic. Yeah, I think it's important to open up a bit to this topic, and I think opening up, yeah, will also result, yeah, in rules to change, or maybe also specific rules to be created for this, yeah, because there are specific in the financial sector areas where they are very restrictive in this topic. Maybe it's a little bit an ambivalent attitude, because towards customers they are very restrictive, but internally, of course, they are very interested in this topic as well, and are also dealing with blockchain and everything. But I think a general, let's say, opening up to this entire world, I think this would help very much to improve the legal regime and also the general conditions in Austria for this entire concept.
Brilliant. Okay, yeah, and I know that we, talking of other countries off the top of my head, that we produced a comparative analysis paper with the Liechtenstein government last summer, which I think we looked at the top 9 jurisdictions for security tokens. Obviously, that's 2021. Bit different now, and then we've got a series of videos which we just did on Hong Kong and their landscape, and on Monaco as well. So yeah, we're just aware there's plenty of other ones out there. I appreciate we're all flying our own flags.
That's a really good example, because I remember when I had the first time this Liechtenstein Act in my hands, yeah, providing on tokens, it was for me like, it was unbelievable, because to have something similar in Austria or in any European Union country was not, you could not imagine something like that.
Both the Liechtenstein approach to regulating this and NFTs, that thank you very much for bringing this on board, because you can make tokenized securities with NFTs also. Well, the Liechtenstein did what we suggested in the blockchain resolution of the European Parliament. Instead of making one regulation for its different use of token, they created a regulation about tokens, and they put everything under this approach. When the people of MiCA realized that it was not feasible this to happen in MiCA, they tried to push NFTs into this regulation, but it was super difficult for this to happen. It was the European Commission against everybody else. The European Parliament has already in its pipeline an own initiative report on NFTs, because MiCA says the European Commission should develop a bespoke regime on NFTs. And this is the sad story with crypto assets in Europe. Whenever we have an innovative token out, because of this approach, because we didn't follow the Liechtenstein approach, we need to create a new regulation for the new beast. And this is really, really sad. Yep.
Yeah, yeah, I would totally agree with the Liechtenstein perspective, but what I would like to point out, maybe not looking some good regulatory environment outside of EU, speaking from experience, how the issuers are looking, because, you know, the securities laws are not fully harmonized through European Union. So for example, as it is the problem with paper certificates, with the securitization process of financial instruments in, for example, Germany and Austria, there are some countries which allows for issuers to have this so-called self-custody of maintaining register of shareholders by themselves, you know. So funny thing about Liechtenstein was, this was before the Blockchain Act was adopted, that, you know, this is a small country, and they have this sort of guidelines for the companies, how should they maintain their shareholder registers. And there was actually a, let's say, suggestion that they use Excel, you know. So this was the reasoning behind all this, because, you know, if you think about it, you know, if the issuers are and companies are allowed to use Excel as a technology, therefore, why should they be limited to not using blockchain technology, you know? And this was the whole reasoning behind this.
Cool. We've got just under 11 minutes left, so I thought I'd see if there's any questions out there yet. Start at the front. Have you got a microphone?
Or I can just yell.
You can yell.
The question came about other regulatory frameworks or environments, and I realize, I stop yelling now. What's our perspective on, I guess, specifically the UK and what they're doing and how that plays with the EU? And then also, I had a conversation 6 months ago with the regulatory authority in Thailand, and they think they're like perhaps world leading. They're trying to be. So I'm curious about our perspective on that as well.
Anyone want to jump in first? Ed first?
I can't talk too much for the UK actually. They for now they still have some of the European legislation in place, I would say, but maybe that will change in the close future. Don't know if they take a different approach. To what extent? In terms of Thailand, I don't know anything.
Well, in terms of the UK, I can reassure you that there will not be such thing as equivalence with the European Union in the next 5 centuries.
Anyone else want to ask questions about the UK? No, good. Any other questions on regulation? Yeah. Oh, we'll come to you next.
Yes, there are many new laws coming up. For example, in Germany, the European, the Electronic Security Act, and we have then MiCA, and we have the DLT pilot regime. Maybe you can give a little bit more clarity. I mean, MiCA is clear so far. The stablecoins are not included in MiCA, but how about electronic securities? Will they detach the security tokens, or is the DLT pilot regime then makes them unnecessary? Can you give a little bit more about the differences about the upcoming laws?
Before we come to Lutz.
Yeah, the MiCA regulation is more interesting about the things it doesn't regulate. What it regulates is the crypto asset service providers, 2 families of stable coins, asset reference tokens and e-money tokens, and what we call utility tokens. Of course, I don't know what's the position of a utility token in a financial regulation. This is another story. What it leaves outside is security tokens, MiFID applies. It doesn't regulate NFTs. A bespoke regime is coming. It doesn't regulate decentralized finance. It doesn't regulate lending crypto and staking crypto. And it doesn't regulate using crypto as collateral. Some people say that we are going to have a MiFID too soon. I don't believe this is going to happen. What we are going to have is 18 months from the adoption of MiCA. We will have 3 or 4 different reports from DG FISMA giving regulatory guidelines, not necessarily regulation, on how to deal with issues like decentralized finance. And Bitcoin is not in MiCA because it's the output of a decentralized protocol. Was it clear? What is in and what is out?
Lutz,
Actually, nothing to add. Maybe just one more point. You have to make yourself clear that there is no private law in Europe. Yeah, so the electronic crypto securities, that is actually private law, German private law, which is the reason for happening on the national level. Yeah, so that is required in Germany. In other jurisdictions, you don't need that because you don't have this requirement of paper-based securities.
But maybe also as a which can serve as a clarification regarding your question, you can say everything which can be considered a financial instrument, so in particular security, does not fall under MiCAR, it falls under MiFID. You are actually in the traditional capital markets regime, not in MiCAR. And I would say only such tokens fall under MiCAR, which are in any case not to be considered a financial instrument and fall under those definitions, are a utility token or e-money token or asset reference tokens. Those three types fall under MiCAR, but they are not securities.
Okay, so we take a couple more questions. This gentleman here, he was first, and then.
Thank you. So we heard about different regulations and different possibilities to create security tokens or tokenized assets in the European Union. Now, let's think a few months into the future, next March, the DLT regime comes into place. How will the landscape look like? How will like a DLT MTF in your opinion look like? Will there be one marketplace where tokens from the Liechtenstein container model be structured or traded, as well as security tokens sui generis, as well as electronic securities by the new law in Germany and different kinds in Europe? That's my one question. And then another thought, we've spoken about effective trading of digital securities will only really be possible once we have a digital euro. We heard as well the opinion that that will never come somehow. And how will trading look like in your opinion on a DLT MTF? So what will be traded against a digital security? Will it be crypto? Will it be a stable coin? Will it be a fiat money?
Who wants to take that one?
Maybe I try. I think, but this is also really my personal idea on that, because all of us don't have any glass ball and see the future. But I believe that we will see that in each jurisdiction at the beginning, maybe in many jurisdictions, let's put it like that, there will be several of those platforms establishing. And after this, we will have a consolidation phase. Maybe some of them will go together and some of them will fall away. Because if they go together, they are stronger, of course. But I think we also have to take into account that it's only a pilot regime. It's a sandbox. So the regime, this is just a sandbox, and this is also going to change, yeah, because they will now monitor how is this developing, and this will adapt, yeah, to the actual requirements of that. But I think we will see in the first phase the establishing of several of those platforms in each jurisdiction, which will, as I said before, stimulate also companies, issuers, to go out and make security token offerings, because now they really have a secondary market.
It's very important to specify some limits here. For equities, the underlying asset that can be tokenized has to be 500 million. I don't know, you will give me actually your insight. Is it big? Is it low? Is it there to facilitate the channeling of funds to small projects instead of unicorns and major companies? Maybe 500 million is a good beginning to start playing with it. The 6 years horizon of the program is too long to me. And another challenge I see that we didn't have, I think, the opportunity to discuss is that it blurs the line between regular exchanging of tokenized assets and over-the-counter. I mean, over-the-counter is a major challenge in this field because you can have your wallet. You can easily transfer over-the-counter with my wallet the security, and how you are going to monitor it, how you are going to report it. These kind of elements are going to be very interesting in the coming years to explore. And regarding tokenizing debt, I don't know what is the point over there, why to have 1 billion and limits of 6 billion for debt and only 500 million for equities. This is something that we need to explore further.
So we're taking one last question, a brief question and a brief answer.
Thank you. Yes, we're trying to tokenize equity as direct investment in companies. So we would not want to go via debt as it is in Germany. We would want to go into equity tokenization, and we're looking at Liechtenstein and Switzerland. And it seems that Switzerland is also some kind of attractive regulated place. So I just want to hear your view on that. What are the differences? What are the advantages and disadvantages in comparison to Liechtenstein?
Maybe all I want to say is that under German private law, it is also possible to tokenize stock companies. Yeah, so tokenize stocks, that is actually possible under German law as well. So could be an option as well.
What I'd say is have a chat. We've got a tool where you can benchmark different countries against each other for their regulations. So I'll take you through that after.
All right. Thank you so much. Give a big applause to our audience, to our panel, and to the audience.